Good evening, everybody. We are live. So, well, um, been interesting tonight. I think. Uh yeah. Woo, Darrell. My man. This was huh. Yeah. I mean, there's a lot to say here. A lot to be say. A lot can be said. I mean, holy cow. Holy cow. This is stuff I've never seen before. I'll be first to admit that. And thankfully, it's not going to take all night to get through it. So we're going to start, I guess, from the beginning and go from there. Give everybody a couple minutes to show up, though. Hello, everybody. Radix, hello. Everybody's here. Who got first tonight? Who got first? Oh, Bren. Congratulations, Bren. You are in first place tonight. Congratulations. Gotta respect that, getting first. Lucius, everybody. Wow, we're getting a whole party going. So he did. He did. This I listened to bits and pieces. This is a bit interesting. A bit interesting. Michael says, "What are we drinking tonight?" This is school night. I gotta get some work done tonight, and I got court first thing in the morning. So nothing special tonight. Nothing special tonight. Just apple juice, and I mean apple juice. No, nothing fancy. While we're waiting on people, I'll give everybody a couple of minutes. We can do some meme watching, which I think would be very fun. Real quick, I think these are some good memes. Yes, the esteemed fort grounds, a fortress known to none others. There's some other good ones out there. I think there were some really good ones. Some people had sent, and these are other ones that I found. Yes, no girls allowed, no grounds allowed. And I'm sure that Bible, I'm sure that Bible's getting a workout. Not sure what it's doing for you, Darrell, but I guess keep doing it, brother. You'll find a page or two in there maybe at some point. Hopefully. Just there were some good ones. Yes, Mr. Soros. Yes, I think your plan is going perfectly into action as you sprinkle discord and chaos into our country. Well done, sir. Well done. Yes. And a little bit of a callback to the 90s for everybody. Howdy, neighbor. Good old Wilson. I didn't know Wilson was the one who killed all these people. He was such a nice guy. Oh. I think there's one more good one. There was one more good one that I found. Where is it? Oh, it might be. Oh, where is it? It's got to be around here. Nope. Oh, crap. It's gone. Oh, well. I can't find it, but that is fine. Things happen. Yeah, I missed all the fun. We're going to go through it. Though. Yes, Frederick Agard. Yes, Fort Grounds 2022 to 2022. Never forget. Remember, though, there were multiple Fort Grounds. Just like the Temple of Solomon, it was rebuilt, and we will commemorate it. All right. Locals. No, I didn't have time to get things set up, Matt. So I don't know. Real quick, I'll give everybody a minute to show up. See if I can set up a locals chat real quick. Let me see if I can. How do I do this? Yes, as you guys probably know so far, the defense is rested. That's it. It is all set. There's no more that can be done. How do I set this live chat? See if I can boomer this. Location settings. Oh, enable live chat. Here we go. All right, here we go. All right, here we go. Sorry, guys. All right, good. Okay, yes. There's a live chat now. So if you guys want to live chat locals, there you go. Hadn't figured that out yet, but we're all done. The alleged defense. Why do you torture yourself watching Brooks? Because we like it's hard not to watch. It's funny, but it's a super serious thing that occurred, and it's hard not to watch. There's curiosity. There's a morbid curiosity. We all have it. We all really have it. We all have it. Memento Mori says local sounds like a gay hookup site. It does, but I mean, you could do it there if you want. It's entirely if you want to do that. That is your call. Okay. So, yes, as I pointed out, the defense rested today. Kind of. Well, it ultimately is over, but not by Darrell's accord. Tweety, I think that's actually a very good way to phrase it. This is the theater of the absurd. And it is. It is. And we're also kind of gluttons for punishment, but we also want to see this guy did a heinous act. And I think part of it is we want to see what kind of a guy would do this. And I think we pretty much what we thought, other than being an evil genius, is just a complete dickhead. And I think we're going to start with this morning. Wow. Oh my gosh. Yeah. 100,000 people were watching Law and Crime today. Yes. Because this was going to be the big thing. I thought he was going to testify. 100% I thought he was going to. It was very interesting. But we're going to get started on that because I think it's worth covering it. And if you guys don't want to watch it along with me, you have to because that's what we're doing today. But I think it's important to watch because we didn't get too far. And we shall start with things going from here. Now, I thought it was very interesting. Let's get to where the sound comes in.
CF 1848, may I have the appearances, please?
Morning, Judge. Sue Upper, Leslie Basie, and Zach Woodshell appearing for the state of Wisconsin.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning. All rights reserved.
All right, good morning to you as well. The records reflect the individual known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
And for the record, I don't consent to being called that name.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is.
Oh, real quick, James Freeman. Hello, James. How you doing? So this is Darrell Brooks. He's the guy who did last year the Waukesha Christmas Parade. He drove the SUV through the parade, killed 6 people, wounded and injured upwards of 65, 70 other people. So this is that guy. He's been representing himself throughout the trial, and now he's to the end of his case. His mom was supposed to be the last witness for this morning, and it looks like she's not there. So the next step is he going to represent himself? And that's where we're at with this. So that's where we are.
Your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
I haven't looked. Let me look.
Actually, I just went to you and then one to the prosecution. Is the audio on?
It is. The audio's on. Do you know when you sent those?
Saturday. So that would have been the 22nd.
State receive anything through like the inter-office communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection.
From you, sir?
No objection. I definitely want those documents received if they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are 2 ICF forms?
Yeah, one addressed to you directly and one addressed to the district attorney's office.
I like how he describes that to the district attorney's office. I'm sure they loved reading that form, whatever it entailed. And this is the one thing, though. This is some hardcore typing. I mean, this is some like hacker ASMR. Just a bit much to me, at least.
I'm sending that. I will send it with high
driving
importance
me
and
crazy.
see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is
Yvonne, this is from this morning. This is not live.
pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
Right? What information make enough of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz question was asked of did he know if there were any recalls on that vehicle, and I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact,
Now, a Brady claim, guys, is Brady versus Maryland. It's a case went to Supreme Court where exculpatory material was withheld from a defendant. Supreme Court said, look, you can't do that, and it's called a Brady. Now in cases, even in state cases, it's called a Brady violation if you withhold exculpatory material in a criminal case. Now, he's claiming that there were recalls on these cars, in particular Ford Escapes, with the throttle body. And his argument, I think, is now he's trying to fish it in there saying, well, maybe I could have not stopped in time. But we'll see how that gets handled. And also, Yvonne, this is from this morning. We are not doing this live. Well, we're doing it live, but this is from earlier.
fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is,
Mr. K, you're 100% correct. Because I went ahead and looked this up while I was at lunch. I heard about this recall. And I actually, because I had a 2013 Ford. Actually, no, it would have been a 2011. It was the old box style Ford Escape. And never had an issue with the throttle body. And you're correct. You actually have to look up what the recall says. It's like, oh, the throttle body is a problem. But what does that do? In this case, it would cause your car to stall. Not just take off or get jammed in the open position. So that's a part of the problem. The other issue is Brady violations are generally evidence that's known or within the possession of the state. Now, that also includes not just the prosecutor, but also the agents of the state. So the prosecutor can't just say, oh, well, the detective had it. The detective works for you. You're on the detective's team. You have control over that detective. You're responsible for it. This doesn't sound like anybody knew about it. And I would assume that this state trooper who did the mechanical research on this car, and I'm surprised that the DAs didn't bring this up during their direct. Were there any recall notices out for this car? Yes. Would any of those recall notices affected his ability to stop the vehicle? No. They should have done that. Now, it's granted, thank God it's coming up now outside of the jury. But imagine if Darrell Brooks had brought that up. Whew. But we'll get to the rest of this.
to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those.
You know how you could have found out if Officer Schultz knew or if the prosecution knew? You could have done that during your cross-examination. So this is also an issue of too late. Sorry. Should have done it sooner, Darrell. You should have done your homework. I mean, all these nights you have, and you have this tablet, you have access. You could have been looking this shit up, but you didn't. I don't know what you were doing. Maybe you should make a new rap video in your cell. I don't know. But you could have been preparing.
Those vehicles. And in light of the fact that these vehicles were recalled because of this malfunctioning throttle body, for
Oh.
I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state, if any?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old. It has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body.
My apologies, everybody. I haven't seen all of this. I've just been told it gets crazy. So it sounds like they did address some of that, and I kind of forgot, and I maybe zoned out a little bit here and there. So they did address some of the throttle body stuff and the recalls. Okay, great. So now they're just crushing this for him.
Failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further.
Now that part, I do remember them saying there was nothing stopping him from being able to apply his brakes. And that part I do remember the trooper talking about. The brakes were fully functional. He could have thrown it into neutral. There was nothing forcing him to keep accelerating. I don't know if that model Ford Escape had an emergency brake, but even like the parking brake where you can stomp on it, all those things he could have done, and it seems like they were all operable. So good job, Darrell. At least the jury's not hearing you crash and burn.
If this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration.
National Highway Traffic Safety
There are, for this
Administration.
particular VIN number for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's a moot issue.
It is moot.
and
You're
I
already
actually
done.
have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models. Like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And
Yes, you generally don't know something's broke until it breaks.
seeing this a class action lawsuit,
A
no
whole
one would
class of
sue the
kids.
Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now, that you can readily view this information about the class action lawsuit, about the recall. On it wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls. And more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email. It's one page with what you said. I have to turn my head. I got to figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only I can read. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother. And from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do. And presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness. Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022.
Sorry, Ray.
I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information.
I don't think your mom told you this.
I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir, but your request
information.
is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
You've had a tablet the
Mr.
entire
Brooks, you're
time.
telling me
dude.
your mother had that information.
No,
So,
I'm
and I'm
telling
going to
you,
trust.
she just told me this information.
So
I
she
have
had
the
it.
phone calls to prove it,
I understand that. I'm
Which
denying your
means she knew
request.
about it.
and I would like a.
So
You
that's
also
my
had your
decision.
tablet.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes,
I now have the
Probably had your tablet.
needs to be-
ICF,
it
the
needs to
one for
be
the state,
addressed,
that you
Your
provided
Honor.
to the state.
It
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of that,
object. I respectfully object, Your Honor, and request a legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration
We'll get
is
to that.
denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks,
I'll have
we
to
need
keep
to
that in
keep
mind tomorrow when I'm
going.
in court.
For the record, may I request
I
a
take
legal or
exception to that,
factual
Your
basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts
No,
and
denied.
conclusion of law on this issue?
Your request is denied.
Denied.
For
That
the
is a
record,
civil
may I
remedy.
respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I
For the
can't
record, may I
answer that
move
yes
to
or no.
state
Now, the interlocutory appeal is when you appeal to the Court of Appeals. Darrell has to do that himself. He can't telling the judge, "Hey, judge, I'm appealing this." Judge Darrell's gonna like, okay, what do you want me to do about? Like, she can't do anything about that. She can't deny him the ability to file that appeal. What he would do is, and what should happen is, if he had attorneys, they could go outside in the hallway, put a motion together, file it with the Court of Appeals, and then the Court of Appeals would, if they thought it was necessary, would send a notice and an order down to Judge Darrell saying, "Hey, judge, hold up, we need to sort this out." Or they might say, "We're not getting involved. If you need to appeal something, appeal it after the fact." But Darrell has to do that himself. So telling the judge you're going to appeal it is like, okay, that's nice. But that's all he's done so far. He said, "I want to appeal." Okay, well, you got to do it.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction.
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact, Your Honor?
Any other requests, sir? I'd like to move on.
Based on the fact you're an
Based on
idiot.
what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been. Your
And they
Honor.
usually
The
will
request
wait
is
till the
denied.
end. This
The
isn't that
request
kind
is
of a
not a proper
problem.
motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor.
Contempt of the law.
Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect.
Yes, but that's not right, Porcelain Thunder.
I would like a motion for finding the fact.
Denied.
Under what law fact?
I made an
By her
oral ruling,
authority
so
as-
there's no requirement I do so. in
Her
writing.
authority as a judge, she has no obligation to do so.
So you're denying a legal, you're denying a motion for finding the fact.
Yeah.
Yes.
So how do I know what you're doing is legal, Your Honor?
If she
All right,
wrote it,
Mr. Brooks, we're going to move forward.
if she wrote it down, it doesn't
At this
change
time,
anything.
I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
it
advisements,
doesn't
and
seem
I'd
like
ask that
you're.
you
I
stop
don't need your
interrupting me.
advice. I
No, I have to
need
give you
you-
advisements, sir, regarding
I
your
need
right
you
to
to
testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right
You don't.
to testify.
You don't
Do
need
you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You
Actually,
need to-
I do so,
Actually,
sir.
you
That is
don't.
required by
Actually,
law.
you don't. You need to do your job as a
Oof,
public
good.
servant
Mr. Brooks.
and honor the oath that you
I
took,
need to go
Your
through
Honor.
these advisements,
back
and
to
if
the
you're
oath
keep
meal.
interrupting me, you will forfeit your right
That
to be
oath.
present, and you
So
will
you're
be
holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements
I
without being
still-
interrupted.
And I
Box
still don't have
oaths.
to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with
I
all due
need you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen,
Mr. Brooks,
Do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying
You
to have a
are,
debate.
Yes,
you are
sir.
I'm
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are
Illinois.
advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
said-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
Don't you
I'm
By
not
not?
holding you
removing
in
me from the
contempt
courtroom.
for the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen,
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this
I'm
court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner, tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
form and
doesn't-
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from.
once he
cameras.
is over there. Again, I'll
It
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement.
More of that tacket agreement, folks. That tacket agreement. Wow, 1,700 people watching, guys. Thank you. If you guys don't know me, my name's Sean Martin. I run the channel Potentially Criminal. I am a defense attorney out of Cleveland, Ohio. I had court today and lawyer stuff to do, so I wasn't able to watch this morning, and we're kind of just going back through the beginning of it, and then we'll cover some of what happened in the afternoon and catch up on some things here. Real quick, I got to cover some things here real quick. Rick Nikita for $10. Thank you, sir. I appreciate the support. This is the Stalingrad defense. Brooks is the starving German army, and the state is the endless hordes of Red Army soldiers. Yep. Everything he can do. The Michael Malloy Show. Hey, Michael, how you doing? James Freeman, please come to my panel sometime. And James, Michael, I left that up there, and I can try to get in contact with James for you. James Freeman, great activist, good guy to talk to, very good guy to talk to. So let's get back to this though here. Real quick, I thought this was funny. Michael McLeese said my throttle body and my Ford Escape acted up, and now it runs 9 second quarter miles. All right, we're gonna catch up to where do we get
That this morning, the neighbor.
There we go. Now we're back to we'll skip ahead here.
Madam Clerk, might I please get verification that the audio and video are working in the neighboring courtroom? All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone,
like you can hear counting, she's
about
so loud.
26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the
Yes, I did.
judge or court to which a request would be made. That is something that would be made to the Court of Appeals. Although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be.
You could almost argue that the other courtroom is like Brooks's summer home. He goes there so often.
Present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me. He didn't raise his voice. He didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through. And I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a
Okay, I'm not going to lie. I don't really need to hear her talk too much.
Provided able to cross
Let's get to the part where
testimony of witnesses. He called
let's
challenging days.
look at that beautiful Bible.
Mr. Brooks, you have been muted. I will make that.
Guys, I just don't need to hear her making the record. I get she's making a record, but we're not live, so we're going to skip to the fun stuff, or the stuff I think will be fun.
That on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we addressing subject matter jurisdiction.
I like that how he's holding the book. He's like, oh, you caught me at an opportune time. Now, it is funny because on Friday, his big argument at the end was, yeah, my mom's going to be here. I tell her she'll show up. Today, it's just crickets everywhere. Yeah, good job. Good job, Darrell. Good job with that one. I'm sure your mom is there. I think we might speed this up to 1.25 times just to see where we're at with things. No, his mom did not show up. She did not testify, guys. So yeah, this is not looking good for Darrell so far. You know, he's like, oh, she'll be here. And as Morgan Freeman would say, and she did not show up. But immediately we go into subject matter jurisdiction. So here we go.
And we haven't addressed when I was just over here, or since I've been over here. Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
Like right meow. Right meow.
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity. You will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted. I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is
that
my audio muted to begin with?
Because
that
you're an
is
ass.
simply a misstatement. I confirmed with the bailiffs that the audio and visual were
Why is
working.
my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now?
Yeah, she's talking to you.
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
Okay, we held up.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record,
Lying
sir.
on the
I've
record.
never-
Lying on the record.
All right, I'm going to mute him once again because
Jeez.
now he's raising his voice. Now he's angry. He's thrown the headphones.
Wow.
He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present
I've never
any
done that.
additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case.
Wow. I mean, she has the authority to do that, but I've never seen a judge do that before. So yes, I mentioned this, guys. There are a lot of firsts today. I've never seen that before. That is, yeah, like I said, so the judge kind of rested part of his case for him. And yes, she's going to be justified in doing that. And we'll skip to, I guess, where he talks again. But yeah, that's been interesting.
Case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my
So yes, your right to present a defense is not unlimited. There are rules, there are restrictions, and you can have them taken from you. I've never seen this ever happen before, though. So yes, it is interesting, and yes, good job, Darrell.
findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. ask Mr. Brooks to put on.
Now, there are a lot of advisements a court does give somebody if they do regarding the Fifth Amendment right to testify. Remember, he has the right to testify, he has the right not to testify. If he doesn't testify, the state cannot comment on his silence, and the jury cannot use that in factoring in whether he's innocent or whether he's guilty or not guilty. But, I mean, let's be real. If you tell them there's two sides of a story, then you don't take the stand. Well, they're going to draw an inference there. So, yes, she's got a lot of advisements for him, and because he's pro se, she's really going to have to go through these. So let's see how this goes.
His headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking
Very good
with
question.
him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Brooks, you're unmuted.
He's unmuted.
You're unmuted. Just speak for everything. I'm here. Can you hear that?
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turn. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that?
Uh-oh. He's got the
No
angry
response
face.
by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol?
He's high on life. Jesus is his high now.
I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that.
She's not calling him stupid by pointing out that he can read and write the English language and he has a 12th grade education or the equivalent of that. That is merely laying out on the record that it is clear he understands the words she is saying and that he's fluent in the English language and that is his first language. So she's not calling him dumb. She's pointing out for the record that he understands what's going on. And for him to sit there, he's not sitting there paralyzed with fear. He's sitting there and being a pouty little girl. So she didn't call him dumb. This is actually part of any sort of colloquy that a court has with you, especially like a plea hearing. They will ask, can you read and write the English language? Do you understand the English language? How much education do you have? So this isn't that. It's not her calling him dumb. And Dr. Mimo, we're not going to go 1.5 speed. We're going to skip to some parts real quick, but I just want to get through this. See, looks like this is the part where he loses it all.
Anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
You've got headphones next to you.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
Feisty.
Clearly, he heard me say that for him to make that distinguishing
I'm
statement.
I'm sitting right here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell me?
I will ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me?
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no.
This is how it
and
goes.
that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case?
Holy shit, this is how it goes down. Wow.
There's no response by Mr. Brooks. I will ask it yet another way, sir.
Wow.
Do you want to testify on your behalf in this case.
Am I unmuted?
Yes, you have been. Sir, do you want to,
How long have I been unmuted? 'Cause you just
sir,
said-
do you want to testify in
You
this
just said you
case?
was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
ain't
you
asking
want
me
to-
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer it for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer. I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is
Yeah,
efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple
She's doing a good job.
requirement
This is
that he
crazy,
answer
though.
questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct.
Wow, she's going to do it.
I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right
Yes, you're
to
unmuted,
testify?
buddy.
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing not to answer that. Sir, you are also advised that you have a
Wow.
constitutional right not to testify.
Your Honor, with all respect, you've been trying to.
Did you hear me say that?
answer questions for, I didn't hear you ask me anything.
You got your headphones on. How can you not hear her?
And I
Sir?
don't understand.
Stop talking and
Dude.
I'll ask it again. Sir,
Can you ask me to stop talking
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
Yeah, I can hear them. I got the headphones on.
All
We'll
right,
talk
then
about
let's,
this, Denise.
once again, Mr. Brooks is being disrespectful.
Yeah.
He is
That's not being
blurting out
disrespectful. I'm
information.
saying
He
your
reverts
fact.
back to subject matter jurisdiction. He
saying your
accuses
fact.
this court of not honoring its oath. He just accused me of practicing
haven't.
law without a license. Again,
You
all
No,
attempts
I said
to
practicing law
deflect
from the
away.
bench. I
I'm
said
going to mute him
practicing
once
law-
again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a
Of course,
tactic
it's all
on
he
his
does.
part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon
Thank you.
pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement
this.
that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme
No,
Court
somebody sent me the timestamps for that.
was faced with a similar
We'll
situation,
get to that.
although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v.
She's
Anthony
leaning into him. Good job, Judge.
discussed, The right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that conduct waiver where again, as I've and says right decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today, based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify.
Fuck. Oh, damn it. Okay, yeah, there we go, guys. Sorry. Wow, I have never seen that before. She literally just nuked him. Nuked out the end of his case like that. Wow. That is never seen that. Never seen that before. Hope I never see that again. That is a drastic action. And I think somebody was asking, can he appeal all this stuff? Yeah, he can appeal all of this, but he's going to lose. His judge, and Steve C, I think, said it best, and I'll mention, thank you for the super chat, by the way. She saw us coming and did her homework. Yeah, she was 100% prepared for this. And good on her for doing that. And by the way, Steve, thank you for the super chat. She 100% prepared. And yes, I know, guys, I boomed hard. Oh no. No. This is uncharted territory. I mean, this is huge. Now, there's probably cases where things have happened, but this is yeah. Yeah, this is good job, Darrell. I think we'll just finish this up real quick and we'll skip ahead to the box forts and whatnot. Okay, J Mike. That's too much. That hurts personally. Oh, let's just see what she does going forward here.
With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor, thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense.
So that's it. That's how this trial ends. The presentation of evidence is now done. The state has no rebuttal, which I'm surprised they don't. But you know what? They probably, looking at their case, think we've got it good enough. There's no reason for us to continue. There's no way the jury's been confused by his nonsense and all the gibberish he just put out there. Yeah, good job, Darrell. Oh my gosh. Oh, we're going to keep playing, Renee. We're going to keep playing in 1 second. We're skipping around a little. I don't need for him to tell the jury that they're going to rest. That part's not really important to me. You know, we're going to skip ahead here to through all the jury instructions. There's no point in doing any of that. He disagrees with them all. We know that. But we get to start with the beauty of in this part, somebody texted me a bunch, or somebody sent me an email with a bunch of these timestamps for the box forts. In this part of the video, we're just going to get to those real quick. I think they're so funny. Because I did see gifs of this already. So we'll skip ahead to those. But yeah, this is it for the court. This is it. It is game time now. The jury has been instructed. There's nothing else for them to do for the day. They were sent home, and they went through their 107 pages of jury instructions. Guys, that is going to be awful to sit through. As the judge said, there's 70 so of them before closing arguments even begin. Which, oh God. But let's get to the fun stuff now.
Language from the amendment, from the amended information on count 70. No, I don't want to do that.
Yes, Cindy, it's very interesting. Darrell's taking cover. He's preparing for the attack.
76. The 76 count. Just want to make. It says near Frame Park, so it is in there. But that was just one question I had. All right. So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
Look at that fortification. It just stands out there like the Rock of Gibraltar. You can't assault that. It's impregnable. It's the biggest castle you can find. Just his fortress of solitude. Oh, okay, DC, rebuttal witness. I'm sorry. We actually have a legitimate question. We're going to answer this real quick. A rebuttal witness. The prosecution has the burden of proof. Therefore, they have the last say on everything. So, after the defense is done presenting their case and they rest, the prosecution has the right to call a witness in rebuttal. And a rebuttal witness is not introducing new evidence, but it is meant to rebut anything presented on defense that may cast reasonable doubt onto the state's case. And that's because they have the burden of proof. So sometimes they will call a witness. Sometimes it's the detective, or a witness has already testified if new topics were covered. Now, it's not generally if the defense calls someone up and they do their thing. It's a witness that wasn't ever mentioned already that they bring up. Or it's somebody who testified right at the beginning and we haven't seen since then. That's typically what a rebuttal witness is. And then also in closing arguments, the state gets the last word because they have the burden of proof there. They get a rebuttal argument. So the prosecutor goes, Darrell Brooks will go, and then the prosecutors get to do a rebuttal argument saying, hey, look, all that stuff he told you is wrong. Here's why, because they have the obligation to prove the case. So that's rebuttal witness. And DC, if that doesn't make any sense, throw a question back in there. I'll try to find it and see if I can explain it. But just this is impregnable. Something surpassed Metal Gear itself. Just look at that. That is beautiful. Judge Mommy doesn't care.
Mr. Brooks is requesting to go back to his cell at this point. I'm going to deny that request. He can remain in the other courtroom.
Oh, yeah. He wanted to go back. Oh, he wanted to go home. Aw. Poor baby. You don't get to go home. You have to stay. It must be John Cena because you can't see him. Yes. Jules B says he built his summer home. Yes. Jordan Patterson, yeah, he's lost all control. We'll talk about this, Doug. Prosecute. I haven't even seen him there. All right, we're gonna skip ahead. Where are these other things someone sent me? Okay, 226. I guess is somebody says a little bit further along. It gets funny again. He's trying to peek over the top, like, hello, I'm right here.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
He's yelling at the top of his lungs. That's awesome. All right. Here we go. I think this
was identified by numerous witnesses as him wearing a hoodie or a light-colored
okay,
top.
I'm almost there.
So I can't presently see
Here we
his
go.
face. I see his jacket is off, so I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted.
Yeah, she's hearing him yell through the wall.
I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests
Yeah, it's like a raptor.
as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
Very good Toledo reference, Dan. I understand this.
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind it.
Attorney Tom couldn't reach that high either.
He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third one.
They destroyed his temple, smashing it to the ground.
Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Yes, his defenses have been breached.
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or
Hey,
otherwise?
man, you don't gotta talk to me like that.
What
Do you
talking?
have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though, cause.
As it
nothing
relates
I've
to
been
the
trying to
jury
get done
instructions,
is-
sir, what are your?
I heard what the hell you said, man.
Jesus.
Mr. Brooks, that was very
Woo.
disrespectful.
Yeah, and I didn't get.
I was about to say, somebody says, yes, salty dog, yes. Oh, he can hear now. Gosh, we are like fired up here, Darrell. Rich G. Ha! Oh my God, that's good. I said tack it, not take it. Oh God, this is getting good. That's George Alvarez, 4 crowns will rise again. Oh God, this is good.
Disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have
Welcome
any
to Earth.
requests?
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't give consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm gonna mute him again because he's not answering the questions that I'm very clearly asking
Oh
him, and
my
I've given him
God.
5 opportunities.
Oh my God, this is
Mr.
great.
Brooks, do you have any requests as it relates to the jury instructions?
I
I'll
wish we could
unmute
have
you
shared
for
this
that
live,
answer.
guys.
I can't hear everything you're saying.
That's some big mad.
Mr. Brooks,
Oh my God.
I know the audio's turned up. I believe you can hear me.
Okay.
You've chosen
okay,
not to
hold
put the headphones on. That's
God, have you guys been writing these fucking jokes all day? Holy shit, these are good. Ground zero. Oh no. Never forget. Never forget 4 grounds. God, you guys. Jeez.
your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the
What about
headphones
that
on.
Don't you understand? What about that don't you understand? If you see headphones, you can see everything, you can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
You had
I
headphones
should have
earlier.
asked for 'em. I asked for my boxes to be moved.
I believe they took them
Jesus.
away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop.
Oh my God.
Sit up here and do everything you're doing, and think God don't see what you're doing.
I'm pretty sure
Like
God's
me,
seeing a
thank
lot
you,
of things
okay.
that you're doing.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image of sir. Now it's all this sir and all this. I'm gonna get
Kirk, if you can put it in there, go for it. I don't know if you're allowed to, though.
Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
Oh my God.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge? And I'm
King
already
Kong ain't got
charged?
shit on me.
You can't do that. The Fifth Amendment says,
Oh
the
my
Fifth
God.
Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in.
Now, from what I understand about this, because somebody had actually mentioned this to me, he brought the bail jumping thing. I think he's being charged with whatever offense he did here in Waukesha as a bail jumping offense, and then he's being charged in Milwaukee County with a bail jumping offense. So it's not double jeopardy. He's being charged with the same type of crime, but it's for 2 separate actions occurring in 2 separate jurisdictions. Now, yes, if they both had tried to claim he had done that crime as the exact same action, yeah, then there might be an issue there, but that'd be a jurisdictional issue. But from the way I understand it, him fleeing counts as bail jumping in Wisconsin. I'm not 100% sure. But either way, his arguments don't work here. They don't make any sense.
Jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect, but don't want to give it.
Yeah, that's the bail jumping. That's a weird way they have that. That's a weird law in Wisconsin.
Same bail jumping charge here.
Which makes no sense to me, but hey, that's their state.
That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay, wait, that makes sense. Okay, so in Wisconsin, bail jumping sounds like committing new offenses while out on bond. So that counts as bail jumping. Or if you already have absconded from a court somewhere and you go and commit a new offense, that counts under the bail. That's weird. But hey, that's Wisconsin. So they wear hats made out of cheese or hats that look like big pieces of cheese. So I'll let them make that argument.
That's the distinction.
Again, there is no distinction. It's the same charge.
Yeah, Jim, I think that's
It's
exactly.
the same offense. It doesn't mean it's the same factual basis, sir.
He is not
It
charged
is.
with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right,
That's
so we've addressed that, sir. What other requests
Thank
do you
you,
have
Sue.
as it relates
Thank
to the
you for
jury
clarifying.
instructions?
I guess I figured it out.
Charged twice with the same thing. You can't
Because
charge
you're an
me
idiot.
with,
This is where an attorney would help you, Darrell.
That I'm already charged with bail jumping. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're gonna charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
All right, we're going to skip ahead. I think he throws the box for it up again.
The first, I'm not the first.
He
I'll make a
doesn't.
note of that. I don't believe I saw the
Yeah, we're gonna skip ahead to the box for it again. Somebody told me though he gets all mad, and that was definitely worth it. Oh my god, that guy is losing his fucking mind, and Darrell. The past 2 weeks, and all of your objections, your substains, your grounds, your relevancies, all of it. You made it worth it, man. This is worth it. This is the payoff. This is the money shot so far. This has been great. Thank you for giving us something good out of this.
The jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list.
We will rebuild it
state.
bigger, faster, and stronger than before.
Turning to page 61.
Yes. Fort Sniffles.
So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County.
Build that wall.
That form the
10 feet
basis
taller.
for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury
Yes,
instruction.
game misconduct. Build it back better.
Obviously, the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear.
This one will
Some of
surpass
them
Mental
did not
Hero.
have them on, just frankly from prior cases that she and I have worked on. But in this case, I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate. And I'll instruct Madam Clerk to include that.
Oh my god. Oh my god, you guys
As
are gonna
far
make me
as
pee my
where
pants.
it
This is good.
goes, I'm gonna just, any instructions that we add should just be in the
Oh.
numerical order. Unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65.
Okay. I guess he's hiding now. Yes.
So as it relates to this, the state is asking that I simply
Stealth mode 100. Can't see him at all. Perfect sneak. Maxed out his sneak stats. Good job, Darrell. Yes, Darrell's on. This is actually, it's safe to say, just like Vosh, Darrell's on his fortress arc. And just like the Temple of Solomon, it's being torn down yet again.
blocking his face.
Oh, we gotta back up just a hair.
The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there, I'm putting them there for a reason.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Don't ask me no question.
And tell me no
Are
lies.
you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight that second paragraph. I will take that out, but I will include in the paragraph that reads, at
poor Darrell.
times, comma,
Darrell,
Mr.
they
Brooks
just-
has appeared from another courtroom, period. This must not influence your verdict in any manner.
That works too. That works too, Big Willa. Oh no. Yeah. Oh, I'm sure those deputies were having the best time ever tearing those forts down. Oh, jeez. Yeah, Shocker says Trump's wall lasted longer. Yes. Oh my gosh. Yes, in memory of Fort Grounds. Yes, thank you, President Biden. Lest we forget. You know, he was a man, he built a dream. And the government tore it down. It's always how it goes. Yes, notice how he doesn't mouth off to the deputies. Yes. Yes. But remember, guys, it's Fort Grounds. They may have torn it down, but right here, that's where Fort Grounds is. That's your fortress. You are a fortress. And you get to decide who you let in. Let into your heart. Something to think about. Something to think about. We can learn something, even from Darrell Brooks. I know it's a little deep for you guys tonight, but felt it necessary. I mean, chokes you up thinking about it. Okay, so we gotta get to the second part. The second part, this part I did. The second part of this, I got to hear bits and pieces of this afternoon while I was in and out of a hearing, while we were waiting on some things going on. So, we are going to kind of get to the good part of this one. The bald. Jeez. Potentially criminal. So him crying in court was just an act. He's not behaving like a sociopath. Oh yeah, I think it makes it clear. But he also could be like in severe manic states, like up and down, highs and lows. Who knows? Let's see here. We gotta get to the second part. 1,800 people. Thank you guys for watching. I appreciate it. If you guys don't mind, give me a like if you like what we're talking about, and we'll get to now. Where is this? Is the there's two parts in here where he loses his crap that I heard. We'll get to this part first.
Of course, the alternate jurors would be selected. But given,
Am I muted?
no, you're not. You haven't been.
So I got a question about the,
Hold on. I don't know why that's on 2-speed. All right, here we go.
the hazard for use of a dangerous weapon. How's that being charged? Is that under 939.632?
It is in the charging document, sir.
How is that being charged? From my understanding, that the statute reads the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State one is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree recklessly endangering safety charges. So counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah. How is the alleged defendant being charged
So are you asking how are you making a specific request as it relates to the special verdict question?
I would say both. Seeing as how I don't understand how, that's why there's the question. Reading the statute.
And which part of this, I'm sorry, which part of the statute are you referring to again?
I believe it's 939.632.
And your specific argument is what again?
How is that enhancement, how is the alleged defendant charged with that enhancement when reading the statute?
It sounds like he's having an issue with the statute, but it's the enhancement is that he used a deadly weapon to commit all these crimes, which was the car. He turned the car into a deadly weapon. And I think I've mentioned this before, guys. Yes, if I had a gun, that would be an inherently deadly weapon. But this coffee cup, the Brooks Coffee Company out of Waukesha, Wisconsin, you can see on my Teespring down below if you want merch, isn't a deadly weapon inherently. But if I were to walk up to Darrell Brooks and start trying to cave in his skull with it, this could easily become a deadly weapon based upon my intent. Just like a car. Car's not inherently deadly, but if I start trying to kill people with it, then it becomes one.
It says it, well, I just read it, so.
It says, I just read it, though. I was going to tell you what's in there, but I just said it, so you better figure it out. I'm going to have to try that tomorrow, too, if I have a problem in court. We'll see how that one goes.
I believe you're referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Right, that's what I just read.
Well, what's the state's response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime? So it has to be an essential element of the crime. Otherwise, there's no crime. I think it's the essential element. If you read in the statute, it's the essential element. You can't just walk up to someone and quote unquote run them over. There has to be something used in order for this alleged crime to transpire, and that would essentially mean
I don't know what the hell he's
quote
getting at
unquote
here.
dangerous weapon.
What?
So without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a.
Okay, I see what Darrell's trying to argue. He's trying to argue that the homicide had to be committed with a weapon. Well, that's not true. You can use if you use your hands, that's a weapon. But okay, yeah. Okay, no, his argument's completely retarded. Like, I fully understand what he's trying to argue now. Makes no sense. The use of a deadly weapon to commit the murder and reckless harm to public safety are crimes, and then did you use a deadly weapon to do it is an enhancing offense. And the enhancing of the first-degree intentional homicide with a deadly weapon then makes it life without parole. So there's a reason why they're doing the enhancements. And then for the other felony assaults, a deadly weapon enhances the offense as well, greater sentencings. So, or mandatories or consecutive nature, but it's an enhancement. Okay. Yeah. Darrell's completely, I understand what he's getting at, completely stupid. And Jim, I think you're right. You said it. He's reading it in retard, so to him it's retarded. Pretty much. By Franz, is he trying to imply the vehicle can't be a dangerous weapon? I think he's trying to argue it has to say I have to kill somebody with a vehicle. Like specifically, which that's not at all. No, he's just being an idiot.
Dangerous weapon. And so
That's the same argument it is, Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same thing.
it's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
I respectfully object to that, Your Honor.
Understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
Yeah, would that be, will my objection to that be noted for the record?
It is.
It's noted.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
Yeah.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage
Exactly,
by Mr.
Stephanie.
Brooks and they remain in there. That was provided to me by the bailiffs.
May I respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may
Jim, you bringing this up. They're not calling it a deadly weapon by itself. He actually used the weapon to cause harm. I mean, he used the car to kill someone, therefore he turned it into a deadly weapon. The car itself wasn't a deadly weapon until he used it to cause death or serious injury. So yeah, that's why just because you're a felon, if you're owning a car, you're not possessing a dangerous weapon. He turns it into a dangerous weapon when he hurts someone with it. So I hope that clarifies it a little bit.
request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
Bam.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact?
Your request is not based in law or fact, sir.
Oh no, they're not working. He's trying so hard.
I just read a statute that it came from. My argument was based on a statute,
It's an incorrect
a
argument.
Wisconsin statute.
Your request is noted. Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter.
Court's already made its findings regarding the forfeiture of right to
Yes,
testify and the
Luke.
forfeiture
Your
of
words
the
have no
right to
power.
present additional evidence and
Which
testimony.
was not,
I'm not gonna
which was not
revisit the same.
which was not consented to. I never stated that I did or did not want to
Understand,
testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I
Your
didn't
words have no
understand
power here,
the
Darrell.
questions being answered.
Sir, do you have any other
Power here.
questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
I'm
It's
not
level
answering
1
those
rogue versus
questions,
level
sir,
20 paladin.
other than how
Is
I've
that-
already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
Yes, a
Sir, I
judge
will
makes
ask you
judicial
once more.
determinations.
Do you have any other issues?
And I will
To
tell
raise
you once more, I
with-
don't understand the questions that you are asking.
Sir, do
So
you
I
have
will-
any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are
He
asking.
has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the
Yes.
question will be
No points
taken
in
by this
persuasion.
court as a no. Sir, do you have
Under
any
what law of
additional,
fact? Under what law of fact can you say no? when I'm
sir, do
telling
you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
That is
respect
incorrect.
to the
That is
verdict
incorrect.
forms.
That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
Right, did the state have any
She's
other?
forcing you to do whatever she
I'm gonna mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you
yes.
disagree with the court's ruling.
Yes, she showed you what's up there, buddy. Good job with that one, Darrell. All right, guys, in the last part here, this is where it got really good. I heard this part while I was driving home from court, actually. This is super spicy. This is super spicy. I did not see it yet, but I want to see the reactions of things. And yes, real quick, I guess I'll just answer it right now, guys. No, I have so here's what we know for tomorrow. Jury instructions are going to take all morning. It sounds like it's like 70 pages long, and then each side's getting 1 hour for their closing arguments. That's going to happen in the afternoon, and then there's 30 more pages to read. So at that point, let's bring this up. At that point, after both hour-long closings, 30 pages are read, the jury's going to have it. If there's enough time, they're going to start deliberating. If not, they'll start Wednesday morning. But they are being sequestered starting tomorrow night. What I will tell you is the mute button should be tied to the taser power. Yeah. So here's the thing. I don't know. I have a court hearing at 1:00. It's not super long, but I have the feeling I'm not going to be back before. And really, let's be fair. I don't care the state's arguments. They've convinced me beyond a reasonable doubt he committed this crime. I want to hear Darrell's. Now, if I get back and Darrell hasn't done it yet, yeah, I'll go live. But it also might have problems. I don't know yet. I'm planning on going live, I'm thinking. Or at the very least, if Nick's watching, Narcade is doing it, I'll hop on with him if he's doing it. I'll reach out to him tonight and see if he's going to cover it. But I might not be done by then. Certainly after tomorrow night, we'll go through and recap. Especially Darrell's, because that's going to be just like, mwah. And we know it's going to be good because of what they talk about coming up. So I hope Darrell should roll for comprehension. You guys are so mean to him. He's just trying. He's trying so hard. Oh, what if Brooks refuses to do closing? If he refuses and sits there, he can waive it. You can waive your closing arguments. That is not against the rules. That is perfectly something you can do. I don't know why you would do it, but you could. Now, a reason why you might do it is if you realize the prosecutor saved a bunch of facts and things for the rebuttal argument, you might waive closing because then the prosecutor can't do the rest. So, Guy Fella says, do a barrel roll. Yes, that'll help. Hey, Spud Gun. Yes, Brooks the Tool, and hello. Mr. K, guys, we're going to skip ahead about 20 minutes in this. Actually, yeah, about 20 minutes. Here we go. This is where it gets good. I heard this part in the car, and this was just, beautiful.
Us is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument. And so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments.
Yes, prep your ears, guys. Here we go. Here we go.
Now, clerk, may I see the instructions that we have thus far? The packet?
It should be done and printed.
Okay, thank you.
Single side.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning. Because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half.
We'll
to
cover
read
this,
those
Christy.
remaining 30 pages, and we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, Your Honor, and to highlight the important points.
This is also not OJ. This should.
Do you think
it's a
it would
really
be reasonable
straightforward
to give the parties
situation.
each an hour total? That would reserve whatever's left from your initial for any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's
God
looking
can't
at
help
a
you
book.
now, Darrell.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a
But it's
book.
the book, Darrell.
It's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it though? Anyway.
Sir, I'm contemplating.
I didn't hear that part before. What part of Corinthians talks about running down a bunch of old grandmas? Is that Paul's second letter to the Cappadocians? Think not what you may do for the church, but kill every senior you may find with your wheeled chariot. Or is this like somewhere in the back of the Bible, like in the appendix? I don't know. He's using the NIV Bible, so he doesn't have the Catholic stuff in there. There's Apocrypha. Maybe he's referring to stuff like that. I don't know. Or maybe it got deleted by the Council of Nicaea. Oh, but don't come in here. Don't come in here playing me like you're a man of God, Darrell.
putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm
Given,
not doing it tomorrow.
then you'll forfeit your right to give one, sir, because as we have,
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How is that lawful
sir,
law?
if you choose
How
not
is
to
that
give
lawful
one,
law? How is that lawful law?
sir, if you choose not to give
Good,
one,
right.
you're not letting me finish.
I love his. What kind of judge is that? You tell me what to do. Every judge. Every judge tells you what to do. What kind of judge is you? You're gonna give me a schedule I have to run on. No, Darrell. Of course, no. You can give your closing argument 3 weeks from now. We'll just wait. My God, like you're not even trying to be, clever anymore. Now you're just being a dickhead. Like you're not even trying to be somewhat clever in your arguments. Man. Yes. When the tasers hit you, you're gonna sound like that too.
And you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't even let me get my sentence out.
You always want to make a incorrect record.
Do what? No, this isn't live.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sort.
Okay, that's an Eighth Amendment issue, Dwayne. We can't do that. Clear Eighth Amendment violation. Sorry. Cannot change. We cannot make Darrell be handcuffed to Keffels forever.
Probably before the defendant goes, just for the jury's sake and the party's sake, we will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions, and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth, that they have the power. They have the power to nullify laws.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is
okay. Big disagreement here. Yes. So I have to preface this, I guess, real quick, in case anybody from the Supreme Court of Ohio watching you guys right now, or disciplinary counsel ever happens to come across this video. I am a duly licensed attorney in the state of Ohio, licensed by the Supreme Court of Ohio. As an officer of the court, I follow all rules in the state of Ohio, both the rules of professional conduct and the Ohio Revised Code and the United States Constitution. I cannot advocate for, nor do I ever advocate for, jury nullification. But to be fair, a jury, if it enacts whatever ruling it does, if it happens to acquit someone who, even if the state has met the burden of guilt, well, that is their decision, and that should be how it goes. Now, there are states where you can bring up jury nullification. There are a couple of them. Nevada's one. I think New Hampshire is another. There's like maybe 3 or 4 total. And it's called a Fully Informed Juror Act. And in those states, you are allowed to point out to the jury, you have the right to nullify a conviction. If you don't think the law is fair or it's being improperly applied or shouldn't just be enforced, period, you can say not guilty, and you have that right, and it is read aloud, and you can mention that. Everywhere else, if you mention jury nullification, so like, for example, if next starting on Halloween, I have a drug trafficking trial. If I try to go up there and argue jury nullification, oh sweet mother of Jesus, that will be a bad day for me. Judge will immediately, well, if the prosecutor doesn't stop it, the judge is going to stop it. I could easily see myself being held in contempt. Not necessarily jailed, but I could be fined. I could be made a number of things. I would probably get reprimanded by that judge horribly. I might get referred to the Supreme Court of Ohio for that. At the very least, I am going to be on that judge's shit list probably forever at that point. This would be really, really bad. In Darrell Brooks' case, you can't really do anything to him. So what did she say she's got? She's got a curative instruction saying, you can't do that, and she's going to read it immediately. So I think she's prepared for that. He's going to bring that up. But that is what could happen. So I think all states should have jury nullification brought up because jurors do have the right to vote that way. And it goes back to, I think it's called the Bushnell's case back in the 1600s. A jury didn't come back. They tried to acquit somebody and the judge kept them. He arrested them and forced them to come to a verdict. And the courts in England said, no, you can't do that. They have the right to make that verdict. So jury nullification has been around for hundreds of years. Patty, yes. Yes, all gun charges should be nullified, but we're not there. Laying down the fine print. Well, I don't want to have to answer for advocating for that, so I got to be careful. Salty Ball says, I just filed a complaint because your mustache doesn't match your beard. Sorry, bro. Well, hey, I mean, right here, that's a beard. This is the beard. And, like, that's the beard. And then, like, there's some, like, individual black hair still. But let's get back to this. This was hilarious to listen to on the way home. Yes. Oh, hold on here. Walks into flames. Yes. He really thinks they'll do that. Yes. Yes. He really thinks he's going to find somebody. It's like, come to think of it. Fuck all those grandmas. Not guilty. Let's go home. Yes. Yes. Not the mama says this is in England. It's not. But we're built upon English common law. So jury nullification does happen at times. And juries have acquitted people. It's just not something you can bring up. But a jury can make its own decision. So, for example, a completely guilty man can be acquitted. And that is legal. And the state can't do anything about it.
Well,
Clear under the law.
I can raise what I want to raise.
I'll do what I want.
And you can't, so you added in jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your
Now,
right
say
to do
it's
that.
not. Say it is not.
It is
Show me
not
where
your
it's not.
right to raise
Show
jury
me-
nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here. And I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look
Oh, the poor jurors have to walk down a whole
worse
hallway.
than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented. And those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes.
I wasn't going to bring it up, but she almost said sustain. She's heard it so much. It'd be hard not to, but yes, I think she almost said that. I caught it when I was driving. I thought that was so damn funny listening to that. I know I'm not the only one who must have caught that. I don't think you guys are either, but good catch.
Determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concern themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. One other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that
we're gonna skip it. I think he gets mad again.
Yeah. This is a trial. This is not like a guilty plea. So
lock me up,
Mr. Brooks. I'll get you. I'm unmuting you. Go ahead.
He's waving.
Go ahead. You're unmuted.
Trying to land a helicopter. Wave his hands.
And
Like right here.
since we're all making records to make me look bad, I think we should say for the record that one of the rights I have is to demand that the court place in the evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
under-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general, your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact
Yeah.
and are overgeneralizations of what the law requires as well.
I accept for value and return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing. And I also have the right,
Hold up, guys.
to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. That is a military symbol. So is this a common law court or admiralty law court?
Oh, we did it. We did it. We hit all the guys. Darrell hit the sovereign citizen bingo cards. He filled them all out before we got to the closing arguments. All the other issues, he brought the Sestaki trust before. It's that trust supposedly that you have based on your social security number, your birth certificate. And then he brought the flags with the eagles on them, arguing those are military symbols and that if this is an admiralty court or a court martial, he's not bound by them. You son of a bitch, you did it. I didn't think you were going to get there, but you did. Now I'll give it to him. The eagle or the gold fringe, I'll count that as the same thing. So he made it work. He made it work. I'll make a ruling. I'll make a determination in his favor on that one. Good job, Darrell. Oh my God, this is amazing. This is better than like any sovereign citizen compilation ever.
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
And she just told him basically to go fuck himself and walked out. Oh, God, that was beautiful. That was beautiful. Pope Rackets, yes. But did he travel? Has not been proven. Has not been proven. All right, guys. Well, that is it for, Brave Darrell. All right, so we got some super chats to get through, guys. We'll get through these and then a couple more comments. Brenda Plunkett says, and this one I wanted to bring up again because people have asked this a couple of times. Did the state improve intent? They have. Your intent is not necessarily just need to be evinced by, yes, ha ha ha, I'm going to, they found his Dear Journal, like, Dear Journal, today I'm going to run over and kill a bunch of people. He didn't text anybody with that. But when you keep driving through a crowd of people and keep doing it and you don't stop and you accelerate, and as you're like, boom, 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 your actions can be used to infer intent. Intent is would a reasonable person know that their actions would lead to a conclusion and be a very obvious one. Driving your car through a crowd of people, you are going to hit them and kill them. So, yes, they've established his intent. And I believe it's in the Wisconsin jury instructions. Your intent can be inferred. You can infer the intent based upon his actions and his thoughts. But his actions clearly show the intent there. Porcelain Thunder says, why do all mass murderers drive Ford SUVs? Brooks in the Escape and OJ in the Bronco. Oh. Aaron Cox for five Canadian loonies says, "Is it time to resort to the Chewbacca defense? That would help him." Pinochet's helicopter tours. Hello, mi generalissimo. Nick sent me, but I come in my helicopter. Giggity. ICBM catcher for $10. Thank you for the super chat. Freeman, aka James Springer, is nothing but a YouTube actor. His nonsense has nothing to do with rights, freedom, or the Constitution. You have that, and you have the right to feel that way. Scott Fletcher for $4.99. Thank you. Says it's like watching a single mom disciplining her son, then feeling guilty after 2 minutes and giving in to stop the tantrum. Yeah. Yep. The son of Flurpock says, "Will this be case law moving forward?" Not right now, but once he appeals, yeah, it will be case law because appellate cases are what make the case law. That's what other courts will rely on. And yes, he will be cited if there's any kind of spastic people in the future. This will be a very helpful case to go forward on. Other states will probably use it too if, God forbid, they run into similar people. So yes, there will be a lot to gain from this case and will help a lot of judges out if they deal with this stuff also. Denise, like I said, these couple of these are great questions. That's why I started them for later. I just hope whatever he says tomorrow can't be a mistrial at the very last minute because he can say something that affect the jurors. Yeah, Denise, if you're asking about, like, literally there won't be a mistrial. They're going to get all the way through it. The judge will have instructions that are curative, but he can't force a mistrial generally at this point. They'll put him in the other room and silence him if they have to. And if he disrupts, he's too disruptive, she'll say, "Sorry, no more closing argument for you," if he won't follow the rules. Mark D says, "How would this have been different with the legal team?" It would have been a lot better. And they would have probably tried to argue a lack of intent to kill. That there was some provocation, that this is more manslaughter than anything else. But Darrell blew that up. Too bad. Pinochet's helicopter tour says, with his water show opening, he'd lose it on the stand. Yeah, and I think this is clear too. Having Sue Opper get up there and start cross-examining him and just needling him, getting in there and just poking him a little bit. Oh, he'd lose his mind up there. Mr. Squiggles for $5 says, she knows these narrations are annoying him. LOL. She's getting back at him today. It's her turn now. Yes. She's like, look at me. I am the captain now. Wrestler Town for $5 says, it's good to see the rare case of someone who actually deserves to get nurse ratcheted. Mm-hmm. TN for $2 says, Fort Grounds breached twice this day in history. Never forget. Jordan Patterson for $1.99 says, a classic narcissist who has lost all control. Oh yeah, he realizes it's a game over and the walls have closed in, to rip off one of the famous quotes of MSNBC. Pinochet's helicopter tour says, how deep is the fork in the sovereign citizen movement now? Not at all. Oh, it's like cockroaches. You have not killed it. It is going to keep running. There is nothing you can do to stop it. There is nothing you can do to stop it. It will keep going, and they'll just say, oh, he was dumb. He didn't do it right. I'm smarter than him. So it will keep going. But it has displayed it for the country. Like, more and more people are learning about it. Deg for $5 says, I put money on him getting maybe 3 minutes of a closing argument before he's moved and subsequently cut off. Yeah, maybe. I think he'd get a couple minutes in. Remember, he's got a whole hour. And I assume he's going to use the whole hour. If absent her stopping him, he would use the whole hour. Dan Stafer says, yes, it looks like he's building Parks Tower at the University of Toledo. Yes, like I said, that's a very good one. I appreciate that. TN says, yeah, he's not tall enough to stack the third box. Ash85 for $1.99 says, Dowd, Nash, and White Quad rules. Once again, I think if you got what Dan's reference is, then you'll get that one too. Very good, Ash. Character holding for $2 says his fort has been torn to the grounds. Yes, it's been razed to the grounds. Pope Brackets Touch Me says for $2, what's the one thing you never mentioned to the jury? Lol. Yes. Stormcrow 900 for $10 says, y'all don't understand nothing. Nothing. I'm sure that might come up tomorrow too, or after a conviction. Kirk Burning for $20 says, thank you, by the way. I have a ground shirt made if you don't mind a Teespring link. Yeah, I don't know if you were able to put it in there, Kirk. I'm sorry if you weren't. Coach Platitude for $2 says, touchdown on paper, unmitted. Let's talk about prepping for $5. He got so close to crying. You don't give a damn about me. Yes, he's getting very, he's running low. Spasticus Autisticus for $5. Or no, okay, that was autistic. For £5 sterling of the King's sterling. He should use his multiple jeopardy argument to get his 6 murder charges reduced to 1. Genius. Some galaxy brain thinking right there. He'll be on SCOTUS as soon as he gets out in the year 3422. Yeah. Eric Rollins for $5. Sad. He's taking out his anger probably on the only person in that courtroom who cares about him, at least to make sure that he has a fair trial. Yeah. Although the prosecutors want to make sure it's a fair trial too. Like I said, I've been impressed by this office. They've done a great job of going out of their way to try to make this, above board. No questions about this being above board. Mike B for $10 says Fort Sniffles. Keep up the great content. BG Willett 21 says, all in all, it's just another box in the wall. Hooligan S3 for $9.99 says, if there was ever any doubt about why he did what he did, his tantrums are solid grounds to sustain tacket belief in the charges. Yes. Very true. Dark Lotus for $4.99 says Baldo, formerly known as Darrell Brooks. Once you see it, I saw it. Yep, I saw it. Let's talk about prepping for $5 says, if he was charged with vehicular manslaughter, he'd be correct. But he's not correct. Very true. Yes. Angrist for $5 says, the mute button should be tied to the taser. That would be great. Christy says, what are victim impact statements? Okay, that is a great question. So victim impact statements are, if you're a victim, you have the right to come to court. Or if you don't want to come to court, you have the right to have a written statement read by usually the victim's advocate, who's somebody who works in the prosecutor's office. But under the law and traditionally, if you are a victim, you have the right to address the court at sentencing. And you can say, generally, you're not allowed to come in there and act a fool, but you can show the court, look what this has done to me. Here's what's happened to me. Because yes, he ran people over and certainly broke legs and, like the one lady said, her daughter has a chipped vertebrae, but that daughter has the right to come in and say, yeah, he chipped my vertebrae. I was in a wheelchair for 3 months. I can barely walk. I might not be able to walk again. I'm terrified of, I can't go downtown in the town I grow up in. I can't enjoy the things I used to enjoy. I have nightmares all the time. I'm very upset that he did this to me. And then you also have the right to say, Judge, he needs to be punished to the maximum extent of the law for the offense of mine. Max out his sentence, run it consecutive, or run it concurrent, or whatever you want to happen. You have the right to say that. And that's what a victim impact statement is. Now, in some states, by law, and it's called Marsy's Law or victims' rights laws, that's automatic, but usually it happens. But theoretically, each one of those victims or their representative could come in and make a statement, and they would have that right. Now, the court and the prosecutor is going to try to work with all of them. Like, do you really want to come in and say something? And they'll probably try to parse it down because that'll take forever at a sentencing. But there will be people who are going to want to talk. So, okay, let's see here. Just trying to catch up here, make sure we're all caught up. Well, you guys are like flying along. All right. Then there's one, Sir Marhas for $4.99. Thank you for the super chat. Says, hello, my fellow Ohioan. I found out that Ohio State does not have a good grad program for my degree path, so sadly I'll have to leave next year for the UK. Hey, at least you're not having to go to Ohio State. That's the important thing. Because otherwise you'd have to run around and spell Ohio with your hands all the time. And that's not really something to be proud of. So, guys, like I said about, yes, he will get consecutive life sentences, and he's probably looking at, well, actually, that's a good question. Do you mean UK like the University of Kentucky, or do you mean like, Tea and Crumpets UK? Or the University of Kansas? I don't know. Or that's KU, so. Porcelain, don't start with this shit, Porcelain. Do not start with this. Oh, you're going to the United Kingdom. There you go. Have fun with that. Bren, you were first, but don't make me fucking nuke you. Do not. Ohio State's horrible. Bunch of Philistines. No, I'm not spelling Ohio with my hands. I'm not doing it. Pope Rackets touched me for $5 says, let's get real though about SCOTUS. At least he knows what a woman is. You can tell by his tone of voice. Oh no, that was a good one. Wisconsin prosecutors were probably ashamed from Rittenhouse. I don't know. Who knows how they feel? Maybe they would have felt like, maybe Sue's sitting there like, oh, I thought when good Kyle, he's such a good boy. He shot those communists. By golly, I thought it was a great thing, don't you know? Like, maybe she was all about it. Who knows? Generally speaking, most prosecutors are not keen on people sorting their business out on their own, but she might feel that way. Oh, Brent says, I live in Michigan. I feel you, brother. There we go. Brother. Oh. Sir Marha says, but I have to give up my guns. Yeah, but hopefully it's for a short time, and it's okay over there. They don't have guns, it's safe. Bring a stab vest. I sounded like an Irish Wisconsin leprechaun. I tried. So, guys, that is it for tonight. Wow, it's 8:45. We were going for a while. Fluffmaster brother. Yes, Dutch says, don't get stabbed or have acid thrown on you. Yes. Hey, that's peaceful acid. It's acid of Allah. So that is it for me tonight, guys. If I can get on in time, I will. If Nick or somebody else is on, I might try to figure out a way to hop in on that. But yes, tomorrow is going to be a hoot. Now, I hate to say that because this is a real thing. People died and people have been injured. But it is what it is. So let's see about the poll while we're at it. Will Darrell get sent to his room tomorrow? Or to his summer home? 61% yes. You didn't have to ask, 30%. Mommy is too hard on the boy, 4%, and no, 2%. Well, for those of you out there saying no, I hope you're right, because I hope he just sounds like a spaz, but I don't think that's going to happen. I think he's going to lose his shot. Belandris, Sean calling Deus Volt. I swear I've heard that. Deus Volt. There. If you haven't heard it before. The real question is, will he take his shirt off? Maybe. Maybe. I mean, I could see him really getting like wild. But we'll find out. Aaron, that doesn't have, well, yes, it adds up to, hold on. Well, hold on here. Okay, screw me. 61 and 30 is 91. Wait. Yeah. How the hell does that work? Really? There were 4 options. How can... I don't... Whatever. That's math. I'm not doing it. I'm not doing it. Yeah, we're missing a couple of percents. Yes, Reed County won. Trump won. Oh. Will he build another fort? No, because I doubt he's going to be allowed to bring his stuff with him. Because, well, actually, she might let him. He can claim he's entitled to have the materials there. I mean, yeah, he might hide behind a fort, or he'll hide behind his Bible. And Joe Hill, I think you said it best for tonight. He can only blame his lawyer now. It's that guy's fault. Okay, wait, Nick Dev wins here. Absentee votes, yes. All right. Megan Perkins says, Sean been beaten by basic edition. There's a reason why this is not a channel about mechanical engineering, Megan. There's a reason why I went to law school. So, everybody, I will see you guys tomorrow at some point. And after it's all over, depending on how long things go, we might do a recap, especially what Darrell does. So I'll see you guys until next time. And remember, just because you did it doesn't mean you're guilty.